ಆಯ್ತು ಎಲ್ಲರ ಹತ್ರ.
ಇಲ್ಲ ಸರ್, ಸೀದಾ ಇಲ್ಲೇ ಬಂದೆ, ಎಲ್ಲಿ ಹೋಗಿಲ್ಲ, ಸೀದಾ ಬಂದು ಇಲ್ಲೇ ಬಂದಿದೆ.
So can we start the session, sir?
Yeah.
Good evening, a warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Dr. Amar Kumar Pandey, Additional Director General of Police, State of Karnataka. Sir, we are privileged to have you with us today. Welcome to the webinar.
Yeah. Can you hear me now?
Yes, sir, I'm able to hear you. With immense pleasure, now I would like to introduce our today's speaker. Dr. Amar Kumar Pandey holds a law degree and master's degree in economics from Delhi University. He also holds another master's degree in human rights. He obtained his PhD from National Law School, Bengaluru. As a police officer, he has served the department in various capacities for 31 long years. Presently, he is the ADG of Law and Order. He was ADG of Chief of State Intelligence, Railways, Internal Security Division, Human Rights Commission. As Inspector General of Police in Bangalore Central Range and Southern Mysore Range. He has also served as Director of Police Academy, Internal Security, Vigilance. He has also served as DIG Administration, Planning and Modernization, CID Forest Cell. As Superintendent of Police of Dharwad, Belgaum, Mandya, Kodagu, DCP Headquarters, Administration, Traffic, Bengaluru City. Mr. Pandey has international experience as peacekeeper in Bosnia and West Africa. He has received several medals, which includes Medal for Meritorious Service, Police Medal for Gallantry, President Medal for Distinguished Service, Chief Minister Gold Medal, 2 times United Nations Medal for Peace. In the recent past, it was Mr. Pandey who single-handedly arrested underworld gangster Don Ravi Pujari. Mr. Pandey has also authored a book, The Architecture of Return in Civil War, published by Thomson Reuters. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, sir.
Thank you very much, Mr. Trivikram and all the esteemed members. This is for the first time that I would be addressing such a large congregation of esteemed and learned friends from the legal fraternity. We are quite used to speaking to the police officers, but never in such a large number I have spoken to the esteemed members of the legal fraternity. And being a cop, my ability to carry on with my monologue is also very limited. So I'll try to bring before you my little experience with the subject, that is extradition, perspectives and practices. This subject I chose because very recently, this year only, I was engaged in the process of extradition of a very notorious gangster Don by name Ravi Pujari, who had made life difficult for a large number of people across the country. He has more than 200 FIRs registered in different parts of the country, especially Mumbai and Bangalore, and in Karnataka state. Bangalore and Mangalore were 2 of his major targets. And then there were so many unregistered cases where people simply buckled under his threats and pressure, and out of fear, they accommodated his request illegally. And so if we add all those, so the whole country was under his menace and quite affected by the manner in which he carried out his gangster activity. His one significance, I would like to how the subject is very significant for police as well as the legal fraternity. The objective of the subject which I want to bring before you is that while dealing with the subject and extradition being the subject where two sovereigns or more than two sovereigns are involved, then the legal nuances also enhances in its intensity, gravity, and size tremendously. and any small mistake also either on the part of the police officers or on the part of the legal fraternity, or even on the part of the courts, because courts play a very, very important role in this whole process. Even the smallest of lapse or a mistake or oversight can jeopardize the entire extradition process, and the gangsters and the international criminals, they can take advantage of that gap, and they can evade the remission or rendition or extradition. So before going to the theoretical part of the subject and how it has evolved in our country, I would like to just go through in very brief as to what are the nuances of various terminologies and how it becomes effective. So, this basically extradition is an agreement, arrangement, or a treaty where the two countries come to understand each other and the need for exchange of criminals, like where they feel that the criminal needs to be, if he is misusing a particular state jurisdiction against another state, or he has committed crime in one state and he has escaped from the justice of that state to another state, then a whole detailed procedural law has been put in place where if brought with adequate evidences, adequate informations, and justifying the request for extradition, then extradition can be done. So in this regard, I would like to define that what is a fugitive, the one who has escaped. So though it is not defined anywhere in the law, but it is more by practice, and a dictionary meaning is also taken to explain the word fugitive. It generally means that a fugitive is the one who flees or tries to escape from an enemy, justice, or a master. So this is what is the dictionary definition of fugitive. But for the purpose of extradition, it means escape from justice. And somebody who has escaped from justice and is present in another state, then these two reasons need to be proven beyond reasonable doubt. And then if it is presented in a prescribed procedural manner, then a person can be brought back before the law. So it says that for extradition purpose, it is the escape from justice, and presence in another state is sufficient if the charges are pending in the requesting state. So, and it should be a lawful charge. So what is a requesting state? Requesting state is a country or a state where the person who has escaped from justice, he has either committed a crime or either physically being present himself, or even if he's not physically present himself, but of his activities, the impact is felt in that country. So with this, a country which wants to try a person who has escaped from its net of justice, then such persons are called fugitive, and the request can be made, and the person can be sent back to the requesting state. The state where the fugitive is staying at present, they are called the state which are requested state, like the request from which the request has been made, the state where request has been made. So in this regard, and these are basically, again, this is essentially is the definition which is taken from various European definitions as it has evolved over the years. And primarily the British definition has been very, very critical, and various legal luminaries, they have given their interpretation of fugitive. In India, we had a situation that before partition and before the merger of several Indian states, India was in a very unique kind of a position where we had a relationship with the British. The British laws were also applicable in India, as well as there were various states which were existing in India. And we were princely states were there. And then we had jurisdiction British Empire had jurisdictions outside India. So for this, the British India, it was common laws were done, and which was more dealt under the Commonwealth kind of concept for exchange of the fugitives. And many times the independent states, they will have the extradition treaty along with the British India, or they used to call whatever government of India. So there are examples, various examples are there. So one question arose that, okay, what happens after the country became independent? Once the country became independent, then, it is very obvious that the princely states, which merged to form Union of India, the princely states ceased to have their existence. So the moment a state as an entity ceases to have its existence, then all the treaties, etc., which were effected into as an entity, they also cease. And then the new state, if they have a law on the same subject, then those laws become the laws of the land. So this is what happened, and many cases actually arose before the Supreme Court of India and in various high courts also, and even it went to various courts in England to adjudicate upon regarding the status of the criminals who committed crime in erstwhile princely states, and then they moved to England and all that. The various famous cases are there. So that was also a situation. And like in India, the merger of states happened. Nowadays, we find in international experience also, the countries which have faced civil wars. So many new countries have got its birth. Like in former Yugoslavia, if you consider, former Yugoslavia now is divided into several states now. Several countries have born out of Yugoslavia. So there also this question arose that what is the existence of, what is the justification or legitimacy of the laws which were formed in former Yugoslavia? Will they continue to apply to the countries which are born after the split up of former Yugoslavia? So the nations keep forming and keep vanishing, but it all depends as to what is the existing law for the time being in that country, or how the old law has been incorporated into the new law. So this is again is a one factor which is very interesting about extradition. Then one more principle we find is that with extradition, what is called universal jurisdiction principle. This is a very unique thing. Now, what is this universal jurisdiction? So if we have seen nowadays with modern growth of computer and networking and technology, etc., we have Information Technology Act. So this Information Technology Act, under this act, it is known that computer and computer network and computer related accessories, from anywhere a crime can be committed. So with this has come the concept of what we call the composite offense. So what is a composite offense? A crime, somebody can be seated anywhere. But if the impact of the crime is felt in a particular country, then that person becomes an accused for that country also, where the impact or the loss is felt. So whether such state or such country can exercise under the law of extradition the rights to get a fugitive extradited. Of course, we have a few treaties are also, international conventions are there. Under the conventions, the provisions are there. But under one such law like Information Technology Act, there's a question of what is called, every state has something called universal jurisdiction, and anyone who tries to affect adversely and tries to impact adversely the state or the country, that country can seek remedies under extradition law. The same one also goes with Money Laundering Act also. In Money Laundering Act, we find that there is a reciprocal arrangements. Reciprocal means the two countries or several countries together, they have listed themselves together, and under various conventions and all that, whatever conventions they are with specific provisions, once again, the extradition laws can be effected, and extradition can be sought under that. Now, what is extradition? Our Supreme Court and the Extradition Act of 1962. Once again, the extradition word per se has not been defined, but the Supreme Court of India has defined the word extradition as extradition is surrender by one state to another. So it's a state to state surrender of a person desired to be dealt with for the crimes or with the crimes of which he has been accused or convicted, and which are justifiable in the court of law of the other state. So what is common here is that the crime for which a person is exchanged between two states, he has to be tried for the law, which is also an offense in the requested country where the person is staying for the moment. There is one famous definition is also there, which is generally adopted by most of the countries, and it is by a jurist, Oppenheim. So in Oppenheim international law, Oppenheim, he has explained it. Extradition is a delivery of a person or a convicted individual to the state on whose territory he is alleged to have committed or to have been convicted of a crime, by the state on whose territory the alleged criminal happens to be for the time being. So by and large, it is about location of the fugitive, and the person is a fugitive from law. Either he's an accused or he's a convict. And the idea is to hand over him to the state where he is supposed to have committed crime. So this is how it has, over the years, it has evolved. And of course, this has a few salient features as we have been sharing. One is that what does it show? The Extradition Act, by entering into an Extradition Act or by making a request of extradition, few features they come out very glaringly. One is that the state is competent either to admit or to expel. So a state is competent entity which can expel. And second one is that the state also confirms to the commitment that every crime, a criminal should not go unpunished, and every crime must be responded according to the established process of law. Third feature is that the states between whom the extradition has to happen, they accept the state duty to assist and bring guilty to justice. So these are salient features which are very prominently accepted as a common norm. And there's the Latin word is also there, that offender must be punished ad punire or didere. Like an offenders must be punished. But how to punish? While punishing, what features have to be kept in mind is that it should be as per the human rights of the fugitive. The humanitarian aspect of the transfer of a fugitive should also be kept in mind whenever a decision of handing over is taken. And it should be under the due process of law. The law must be respected. So in this regard, now what are the tools of extradition? What are the major tools of extradition? The first tool is a warrant. And a warrant is the command of the court. So a command of the court in the name of the sovereign to its officer to arrest an offender and to bring him before the court. We all know that a warrant is limited to the court which is issuing that warrant. So in normal parlance of criminal procedure code, a warrant is a command of the state, command of the sovereign, effected through a institution, primarily a police officer and some other enforcement officers also. And it is to ensure that a person is brought before the court within the jurisdiction of the court. So it is territorial bound. However, in case of extradition, we find that a warrant which is issued, this warrant assumes an extraterritorial jurisdiction. So a warrant is issued for a crime committed in the jurisdiction of the magistrate, but through a process, through a procedure established by law, it adopts an extraterritorial jurisdiction. A warrant issued by a court in Bangalore, ACMM first, it is effected in a country like West Africa, like Senegal. So that is the effect of warrant in case of extradition. So I'll explain the mechanism as to how the process works and how a warrant issued by a magistrate in one country, in one court, in a limited jurisdiction, assumes extraterritorial jurisdiction and is affected, and the effect of that warrant execution is seen that a person gets transferred to face law in another country. So this is something, a very dynamic situation with extradition. So normally what happens that in extradition cases, the requesting country where the person has committed crime and he has escaped and he is wanted by the law. So a warrant is issued by the magistrate. Now this warrant is a command to the officer of the jurisdiction of the court. Now the person is not in that jurisdiction, he's far away from there. So then the police officer, under the law, informs the court that the person is absconding, he's not there, and he is suspected to be, or reasonably believed to be, or confirmed to be staying in a place which is far beyond the country, even beyond the country. He's not even in the country. Then the magistrate issues a document or a certified instruction in the sense of that open dated warrant is issued, based upon which a request is made either through the diplomatic channels or through the International Criminal Police Organization to alert the courts in another country that a person who's escaping from the jurisdiction of this court is stated to be in that jurisdiction of that court. Now, this is how the mechanism works, that executive mechanism. It's not a judicial mechanism now. A judicial mechanism gets into the territory of the executive mechanism, and then executive mechanism of, say, for example, India, then through some established procedure gets in touch with the executive mechanism of the country's, another country or a foreign state or a treaty state, and that country executive again brings it to the into the realm of a legal procedure, and where the magistrate in the other country, he does one very critical role performance. The role he performs is called endorsement of the warrant. He endorses the warrant. A so-and-so warrant has been issued in India, and the person is living in this country, in this jurisdiction. So he endorses that warrant and issues a direction to the local police. And then the local police is supposed to execute that direction and bring the fugitive before the magistrate. Now, what is the role of magistrate here? The role of the magistrate in another country is that he conducts an inquiry. Is it a trial? No, it is not a trial. What he conducts is an inquiry. And what is this inquiry? With the bare minimum little evidence, if it is proven beyond reasonable suspicion or doubt that the fugitive who is intended to be served upon or apprehended is the same fugitive who is escaping from the law of India, then there he submits a report after sending the fugitive into police custody. Again, there is a temporal limitations are there, time limits are there. I'll come to that part. And he is detained. The person is detained. Now, once the person is detained, then you see the beauty of this extradition process, that the warrant gets, honestly, in a sense, limited execution in another country, and until all other supplementary documents are provided to the magistrate of that country, then that magistrate reports to the highest office of that country, And then under the extradition laws, the highest office directs the magistrate to effect the execution of that warrant, and the person is surrendered to the police authority, which again under the procedure surrenders to the either through the diplomatic channel or through the designated officer. The person is handed over to be brought back to India. So this is how the effect of a warrant acquires a dimension or a size or a volume or an intensity which is applied internationally, and to that confirms a famous Hindi generally used in Bollywood, that कानून के हाथ लंबे होते हैं. So howsoever far the criminal may attempt to go, he cannot escape the long arm of the law, and actually then he is brought before for facing the trial and all that. Now there are many other things are also there. Quickly I'll just move into that. Now see, it is not just that the substantive offenses are only the extradition offenses. Under the schedules, extradition offenses are listed in our Extradition Act also. And the abatement, the conspiracy, and all the related activities around that substantive offense also becomes extradition offense of the main offense. If that main offense is listed in the extradition Extradition Act schedule, then these kind of accessory activities also, associate activities also get included in the extradition offenses. So now then there are like simple things are there like treaty states. So we have heard that India has extradition treaty with 47 countries across the globe. So now these 47 countries, the treaty are nothing but two countries coming together, making an agreement or an arrangement. So it's either an agreement or an arrangement whereby they agree to exchange the criminals if they are staying in respective jurisdiction, to exchange them under certain procedures. So these are treaty states. Earlier we had also the Commonwealth treaty was there. Commonwealth states were there where the same law used to apply. Now we don't have any, after the amendment of 1993 Extradition Act, we don't have this word called Commonwealth state. Is only the treaty state or the non-treaty state. So even if, treaty states, we have no problem. 47 countries, we have arrangements, and under that, whatever procedures are prescribed, we can have the exchange of criminals. Now, what happens with the non-treaty state? So non-treaty state is very, very important aspect. And I had a personal experience of dealing with the non-treaty state, that is Senegal. We don't have a treaty with the Republic of Senegal. India doesn't have a treaty, but our criminal is staying there and we have to bring that criminal. So when we are dealing with a non-treaty state, then 2-3 aspects we have to keep in mind. One aspect is that with non-treaty state, we have what is called the Reciprocity Principle. What is Reciprocity Principle? It's simple that the person who is going to be, who has committed an offense, and which is also an offense in another country, and in India also. So whenever occasion arises, we can follow the principle of reciprocity to hand over or deliver the fugitive to each other. So a person need not be exchanged for the crime for which other state would not demand in future. So if a country feels that, oh, today India is asking me for a fugitive to be handed over, tomorrow, because of our various relationships, economic relations, exchange programs, etc., maybe some criminal of my country will be in India sometime, even though I don't have treaty, but I may require to request India in future. So if I refuse today, then India will refuse tomorrow. So they don't want an embarrassing situation like that. So on the principle of reciprocity, they exchange and they agree to exchange. and any country can take the initiative, even if they have not made any request in the past. But if India has made a request for the first time, they do it in anticipation that in future, if they need something from India, they'll also get the criminal. So this principle of reciprocity is a very, very important concept here. Now, one important aspect is there that what about the convicted criminals? These are about criminals who are going to face investigation or trial. Now, if somebody is convicted and then he escapes, or if he's convicted in absentia, then what happens? So, in absentia conviction is for the purpose of extradition. It is treated like as if conviction is not delivered. He's treated like an accused only, and he has to face the trial afresh. So straight away he cannot be convicted. He has to be put through the trial once again, and the trial has to happen before he is convicted. So this is one important aspect of regarding difference between an accused, simple accused who's facing investigation or trial, or somebody who's already been convicted in absentia. Now, one more aspect is there that, what are the procedures that is followed? Now, Ministry of External Affairs, who's connected to all our diplomatic channels, they lay down the procedures of extradition. It's a 17 points guidelines are there. In this 17-point guidelines, lot of factors are there, which are basically a procedural aspect, that how the documents have to be prepared, who has to prepare the document, who has to certify in the form of an affidavit, and which is the officer who has to, which rank officer has to make a request letter, and then how Government of India will deliver the request letter to the other country, and how the other country then extradites, and what procedures generally they look for, what kind of evidence they look for. So in this regard, the one very important thing which I would like to share with our honored members is that, what should be the status of evidence? So it is in extradition laws, it is followed that an evidence which is admissible in the court of law of the requesting state. So that is what is followed, and that is what is the standard. An inadmissible evidence in the requesting country, or an inadmissible evidence in the requested country, they cannot be adduced as evidence. So one has to really take care that with regard to a particular specific crime, what is the standard and what kind of artifacts or what kind of statements constitute admissible or inadmissible evidence in the respective country. So we have to really take care of that. Then one very important factor is there, that identification. The identification of the fugitive has to be beyond all reasonable doubt. And once the identification part has to be substantiated by all the evidences available. So in India, we normally follow the procedure of fingerprint, photographs, some identity mark, or some other such document which confirms the identity of the person. In this case, in my case, our biggest problem was that the only photograph that we had of fugitive called Ravi Pujari, that was of 1994 vintage. And that was also in black and white photocopy. And this photocopy machine didn't seem to be a good machine those days, because it had several cracks and marks on the faces all over. It was really difficult to fix his identity. But the most, the strongest evidence that we had, that some wise policeman had taken his fingerprints, which was kept in the document. And when he was apprehended on our request, then the police matched the fingerprint, and that became beyond all reasonable doubt, his identity was established with the help of the fingerprint. So that kind of problems do occur in extradition, that a fugitive is located after many, many years. And after 30 years, 20 years like that, his entire features have undergone tremendous transformation. So we have to be very careful because once you have sent something, then you cannot resend and cannot make corrections. That brings the trustworthiness of our system under question. It questions our credibility of the country. And in extradition law, we have to be very, very careful because the respect and reputation, dignity and esteem of a nation is involved. And it's a exchange program of human beings who are charged with some crime between two sovereigns. So these are acquires a very, very sensitive meaning in many ways. Now, what kind of extradition is not entertained? Generally, what kind of extradition is not entertained? Now, if an extradition is of a political nature, so that is not entertained because countries don't exchange their political fugitives, and the magisterial inquiry in the requested country also has to satisfy himself that the crime for which requesting country has made a request for extradition is not of a political nature. And if it is of a political nature, it will be rejected. One more thing is there, that if the documents are not in order, the extradition can be rejected. And the state, the country, has an unfettered right to refuse to extradite. In its own judgment, if the country feels that it is not fit to extradite, then the country can refuse to extradite, and it is an executive decision. Here, no court in the country can issue orders against the executive order of not to extradite. So a court cannot force the government to extradite a person by way of judgment. It can only say that extradition, if at all undertaken, is right or wrong, or it's as per the law or not, that part. But it cannot instruct the sovereign to extradite. Another very important aspect of extradition laws are that when suppose somebody has to be extradited from India to some country, then the central government here issues directions to a magistrate. It can be any magistrate. It need not be a jurisdiction magistrate. Any magistrate can be directed to conduct an inquiry by the central government. And that magistrate, he cannot delegate it to anybody else. He himself has to conduct the inquiry. And while conducting the inquiry, the jurisdiction of the court, what he acquires, the jurisdiction is that of the same as the Court of Sessions, or even a High Court, or even a Supreme Court. The inquiring magistrate acquires the power to execute his warrant or endorsement of warrant handed over to a police officer to be executed anywhere within the jurisdiction of the whole country. So even if a person, JMFC of first class, if he is given charge to conduct an inquiry into a matter of, say, narcotics or money laundering or anything else, which is considered to be beyond his normal criminal procedure code jurisdiction, but he is not limited by criminal procedure code, he can exercise his jurisdiction as a court of session or even as a high court and conduct the inquiry and submit its report. So these are a few very interesting features are there of Extradition Act, and in fact there are few more which I'll put it in a kind of a write-up and send it to Mr. Trivikram for your record's sake. And I would be extremely delighted if I think I have 15 minutes are left for question answer. I would be extremely delighted to answer any question raised by honorable members. And I know that few points have been left out. And if any question is there with regard to extradition of Ravi Pujari, I would be too happy because that's my first-hand experience. Thank you very much for your patience and having given me a great opportunity to listen to all of you. Thank you.
Thank you, sir, for a intriguing presentation. Thank you so much. Uh, can we now move on to the Q&A session, sir?
Yeah, yeah. Were not there in your list. So what is the provision now adopted is that two things. To, uh, to charge him with the offenses which were not part of the earlier extradition offense. The criminal has to be sent back to the requested country and you have to submit the entire process afresh. This is the law. But some countries have made some adjustment where you have to submit the documents, and even when the fugitive is in your country, you can obtain the consent of that requested country, and consents sometimes are entertained, sometimes not entertained, depending upon what kind of evidence is submitted. So these are part of the procedural aspect of arrangements between the countries. Yeah.
Thank you, sir. Now, I see Mr. Harish was raised his hand. Sir, I have unmuted you. Yes, sir.
Yeah. Good evening, sir. Thank you for an enlightening session. I have two questions. One is the first one is with Malia having lost the appeal in the UK court. And what are the legal challenges and non-legal challenges that has been causing delay in extraditing such economic offenders back into our country? The second one is, what was the delay? What are the reasons for which till date we are unable to extradite Dawood Ibrahim? In spite of UAE, we are having a treaty and maximum number of extradition happening in the list is led by UAE till date.
Yeah, both the questions are extremely, is the concern of the whole country is on both the cases. And in case of Malia, he has applied for leave of appeal to the High Court against his extradition. The Home Secretary has ordered for his extradition and we thought it will happen. But we have to understand one thing, in any extradition process, see, there are three parts are there. One part is the requesting state. The state, the grounds it has prepared for request and all that, that part is there, and state has a duty to seek extradition. The other part is the fugitive part. So the fugitive, three aspects are very important. One, he should be a non-political fugitive. Secondly, the fugitive, all human rights of the fugitive has to be exercised anywhere in the world. The same will be allowed to him in that country, requested country also. And no humanitarian violation should happen. You must be aware that Mr. Malia once raised that the conditions of the jails are not good. So that's a humanitarian consideration. And in UK laws, in other laws, and throughout the world also, it falls under something called the torture laws, you know. The Convention Against Torture, CAT 1948 is there. So that Convention Against Torture, it was covered. So these kind of humanitarian aspects are also involved. So Mr. Malia right now, he is exercising his full legal rights to make an appeal, which is allowed, like in our country also under Article 21 of the Constitution, right to life and liberty is unfettered. Nobody can question that. And within that, it is available even to a foreigner, non-citizen also. Same way, Mr. Malia is exhausting all his legal options. So he's gone to High Court against the order of the Home Secretary. And I think High Court has already, High Court has to uphold the decision of the Home Secretary, which is again, you know, extradition is a very strange mix of legal as well as executive. So legally, you only conduct an inquiry and you see the propensity of evidence towards the sufficiency of evidence and propensity of evidence where the commission of crime has been made out and all the procedures have been followed. But the ultimate decision rests with the executive. So executive has to take a call. In Malia's case, the executive has taken the call. So judicial review is allowed there in the sense that Home Secretary's order can be questioned in the High Court there. So he is exercising his appeal, and I think very soon we should have him. It will not get delayed any further. Only few legal procedural part is there. As far as Dawood Ibrahim is concerned, there are many questions are yet to be answered about him. One is about his location, you know, the identity. location, the place where he is. So there are various speculations are there, but they're more from the intelligence point of view. Now it has to be substantiated. Then a lot of other factors are involved. And the country where he is, that country has to take a call to extradite him. He's suspected to be. So that country has to take a call on whether to extradite or not. Now, he has come under Prevention of Terrorism Act also, and under United Nations Convention also. He is considered a topmost terrorist, where the country in which he is, one important thing we must appreciate here is that about extradition law, that if a violation or a crime is a crime against humanity, if a violation is against humanity, or it is something which is universally a crime, irrespective of the jurisdiction from where the fugitive has come or where he is staying. So if it is a universal crime, like universality principle is there, then any state, in whichever state he is found, that state is competent enough to put him to trial. Or he can be extradited also. So, like in Nuremberg trial, you must have heard. So wherever they were found, they were arrested and they were put to trial in that country. And then they would take a decision as to which place to submit him to. So like that in terror cases, in narcotics cases, money laundering, like that, there are some good number of 100-odd conventions are there, where a person, wherever he is found, he can be tried there. So in those cases, little extradition part is little complicated because of various procedural aspects need to be completed.
And is there chances on the principle of reciprocity, which you mentioned? He may escape.
Yeah.
Reciprocity. He may escape from extradition.
Yeah, if we ask for Dawood, Pakistan will ask for somebody else from our side. So we don't know who they will ask for. Can't hear you.
Right, sir. Thank you. We'll take up one offline question, sir. Mr. Shrikanteshwar Advocate has this question. Does the Extradition Act apply only to Indian fugitives on the foreign soil, or does it apply to illegal migrants on the Indian soil? Kindly clarify, sir.
See, we have to differentiate here that Extradition Act is, as extradition has been defined by various judgments, it is against a fugitive who is lawfully charged and who's staying in some other jurisdiction, or some other country's person is staying for having committed a crime and lawfully charged is staying in India. Whereas illegal migration is dealt under Foreigners Act. So whosoever comes illegally into India without a valid document like visa, so then he's charged under Foreigners Act, and he needs to be deported straight away. So he doesn't need to be put through the process of extradition. Extradition actually is a more tedious process, and it is allowing the fugitive to exercise all his human rights dimensions. Whereas the migrant, illegal migrant doesn't have those liberty and those freedom, and he has to be straight away treated as persona non grata and has to be deported across the border wherever he has come from.
Thank you, sir. Amid your very tight schedule, you have accommodated us. So on behalf of Advocates Association Bengaluru, I would like to extend my heartfelt gratitude for today's webinar, sir. Thank you so much.
Thank you very much. It was honor and pleasure was both were mine, and I really enjoyed interacting with all of you. Thank you so much. Thank you.
Thank you, sir. I'd also like to thank Honorable Chief Metropolitan Magistrate Shri Krishnamurthy Padasalgi, who has participated today in our webinar. I would also like to thank all the police officers and learned members of the bar for their participation.